I also now wish to thank Ed Schmidt for suggesting this program and for making it possible, and ask him to come up to introduce the program.
It is said in the art of war that the spoils go to the victors. In the art of politics, that seems to be the right to engage in redrawing the lines of legislative districts. I would like to introduce today's speakers. On my left is the Senior Justice of the Supreme Court of the Commonwealth of Pennsylvania, Max Baer. And on my right is the former Judge of Superior Court of the Commonwealth of Pennsylvania and presently the Dean of the Duquesne University School of Law.
Hello, everyone. Thank you, Ed. Thank you, John. We'll say thanks later. And thank all of you for coming. In perhaps typical fashion for harried, busy professionals, somehow we were informed that this is a 90-minute program. Until last night when we were informed that we have 40 minutes. So we were furiously crossing out notes, and we're going to do our very best to give you the substance. What we want you to get out of this is twofold, I think. First of all, as you cover the news, and this remains a very hot topic, it will be in the United States Supreme Court again in the years to come, and it will be in state Supreme Courts, and it will be on your ballots for constitutional amendments, all of which we're going to talk about, that you'll understand it. And very few lawyers understand it, let alone lay people. So we want you to go home with an understanding of it. And we also want you to understand the policy, the very difficult policy choices that have to be made. Not by me. The policy is not for me. What's for me will get before you. But for you, as concerned citizens of your state. Maureen and I are law school classmates some 40-some too many years ago. We were both judges. I will tell you that judges are not Democrats or Republicans. If they're good judges, they're judges. And they don't care about party. Having said that, in Pennsylvania, we elect all our judges. So before we were judges, Maureen ran from the Republican side and I ran from the Democratic side, for what it's worth. We've remained close friends forever. She should have been my colleague, but she lost an election for our court. I said to her last night, if she had won an election, she'd not run against me. But I had not lost at that time. I could be the Dean of Duquesne Law School, and she could be the Senior Justice of the Court. We want to give you a wide-ranging discussion. We appreciate your very erudite audience. And so we're going to digress to the extent we can as to topics and personalities, etc. Okay? Maureen, you want to start us with a quick overview of the constitutional law and some of the little case law that arrives on this. A lot of this comes from the federal Constitution. I suspect most of you don't know it. It's buried in the first couple articles. Maureen?
Thank you so much, and thank you all for being here. Thanks, Ed, for arranging this, and the Chautauqua Institution for making it all happen. So, first order of business is, what's the foundation, or to use another metaphor, what's the landscape we're looking at here? Well, we start with the United States Constitution, Article 1, and there are two sections in Article 1 that we look at. The first one is Article 1, Section 2, as amended by the second section of the 14th Amendment, and that deals with apportionment. And I refer somewhat to my notes for the language. It is basically that each state will have one representative for every so many people. Now, the original Constitution had a very small number. The amendment in the 14th Amendment, Section 2, provided it should be proportional or apportioned. So that's where the concept of apportionment.
And having said that, interestingly, the number of people in the House of Representatives is not set in the Constitution. It was 310, I believe, until 1913. It's currently 435. There are proposals floating around the federal government to increase that to 600 because of the increased population in the United States. They're even one to increase it to 4,000, so you would all have much closer representation. Query what they would do with their historic main capital in D.C.
Yes, thank you. So the next article is Article 1, Section 4. And here's the language. The time, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof. So what does it do? Our Constitution vests in the state legislatures the powers to address time, place, manner of elections, and in addition, the power to regulate how those elections are conducted. So, with regard to that, one thinks, wow, what else can Congress do if you give this to the states? In that same article, there is a reservation of power to Congress to make certain laws that assist in the time, place, and manner. And we're going to get to it in a few minutes. The Voting Rights Act. The two Voting Rights Acts came under that section, among other powers. But
Have you ever wondered, as you drive across various states, why your election is on a Tuesday from 8 a.m. to 8 p.m. and other states are on a Wednesday, or yours is September and theirs is October? In your state, you can drive by register, and in Pennsylvania, you can't register without giving a quart of blood. The reason is the reason is that provision of the federal Constitution. It says the states, they place the times in plural, places in plural, and manner of these elections. And that gives the state the right to do anything they want. And in fact, in California, and I don't know if we'll get to it or not, they have what is called a jungle primary. Democrats and Republicans can both vote for each other's candidates. In Pennsylvania, you have a Democratic and you have a Republican primary, and then you have a general against the winners. In California, they both vote for each other's, and then the top two finishers, regardless of party, go against each other. And that's just California exercising its constitutional prerogative. This, incidentally, is the federal Constitution. I go nowhere without it and the PA Constitution.
That's right. Okay, and then the next section is Article 4, Section 4. And Article 4, Section 4 says the United States shall guarantee to every state in this union a Republican form of government. So what does that mean? The Republican form, it's not the party, let me tell you. Republican form of government means this. The government is by the people and of the people. And it means that the citizens are in control of voting who their representatives are. That's point one. Point two is there is no monarchy in the United States. Therefore, this Republican system of having citizens elect the representatives applies to every single state, so that that citizen-driven electorate and representatives continues to exist. And the third is, and this is called the Guarantee Clause, is that the rule of law prevails. Let me give you an example, like no ex post facto laws can exist. That's kind of like a dictatorship type of thing. So the rule of law exists. So just to summarize.
Now, we're far afield, but an ex post facto law is to criminalize something after you did it.
Right.
So you can't drive 70 out there today and change the speed limit to 50 and have them pick you up.
Right. So those are the 3 or 4 articles in our Constitution that govern this issue. Then we have amendments. We have the 14th Amendment, Equal Protection Clause, Due Process Clause. We have the 15th Amendment, which prohibits race in voting. We have the 17th Amendment, which requires popular election of senators. The 19th Amendment, which says no sex discrimination in voting, any voting. The 24th Amendment, which says no poll taxes. And the 26th Amendment, which looks to 18 as the minimum age that applies both federal and in state elections. So you have this whole constitutional context that applies. Now, in addition to that, we have 2 laws, both called Voting Rights Act. We have the Voting Rights Act of 1965 and the Voting Rights Act of 1970. The Voting Rights Act of 1965 really focused primarily on the South, and it was addressing a significant problem where the rural counties were controlling the much more highly populated cities and urban areas. And out of that, you might remember the one provision that required all the states in the South to submit to the federal government their changes in voting time, manner, and place, so that the federal government, the Department of Justice, could review whether it was fair to all. Do you want to talk about the case that there was
We're already
2000
minutes behind.
Well,
Let me make a quick comment, and then let's move to what you can define gerrymander for.
Well, sounds like a plan.
My only comment was that the Voting Rights Act and the case Shelby versus Carroll, in other cases, were to eliminate racial discrimination because post-Reconstruction, pre-civil rights movements, there was no votes for African Americans in the Southern America. And that was okay, everybody looked the other way, until it wasn't okay. Racial gerrymandering is not really why we're going to talk today. We're going to talk about partisan gerrymandering. There is no racial gerrymandering anymore. In the recent U.S. Supreme Court oral argument, in a case we're going to talk about, Hill versus Whitford, the Chief Justice, John Roberts, asked the litigant who was trying to end gerrymander, doesn't this impact racial gerrymandering? He said, no, Your Honor. Racial gerrymandering is outlawed in the United States. We're here only about partisan gerrymandering. I think that's an accurate statement, and I think that's a good statement for our society. So let's talk about partisan gerrymandering.
Okay, and might I just start with the concept of one vote, one man, one vote. Again, a case from the 1960s. It's called Baker versus Carr, and it was an assemble case. Establishing one person, one vote. Nobody could be diminished in their ability to vote. You're going to hear that diminished vote or diluted vote concept as we move into this. Baker versus Carr was later established for federal elections and for state elections. And then we move into some of the gerrymandering.
And just one comment on that. I guess I'm the color man or play by play.
Yeah, I guess so.
One comment on that. Earl Warren, famous Chief Justice of the United States during much of its great decisions, presided over the court in Brown versus the Board of Education in Topeka, Kansas, which you all know, I trust, right? When he retired after 30 years, it said separate but equal is not equal. When he retired at 30 years, he said the most important case in his tenure on the court was Baker versus Carr, establishing one person, one vote. And what it stopped, it was actually a Kentucky case. What it stopped was one district in a city of 1.2 million African Americans and one district in an agrarian area of Kentucky with 36 wealthy farmers. They said you can't do that, you have to have one person, one vote. And it changed the world. So with that...
Right. So as we move into partisan gerrymandering, these are a few of the key words that you're going to be hearing time and time again. First of all, is the issue of redistricting, partisan redistricting or gerrymandering, however you want to say it, is it a political question or justiciable? Justiciable means can the courts hear this question? The second question is, if it is not a political question and if it is justiciable, do the parties have standing to bring the claim? And the third question is, how do you demonstrate extreme gerrymandering? So those are the three questions that we're going to be tracking through as we move on.
So you may ask, how did it get its name, gerrymandering? How many of you have the handouts? Share with each other. We brought about 255. Frankly, it was the amount that I could fit into my biggest briefcase. On page 3, you will see the original gerrymander. And the governor that got blamed for it was actually Elbridge Gerry. Not Jerry, but Gerry. And he was a great man. He signed the Declaration of Independence. He refused to sign the Constitution on principle because it did not contain the first 10 amendments. And he thought that was wrong. Of course, they passed relatively quickly thereafter. He was the vice president under James Madison until his death. He happened to be the governor of Massachusetts at this point. The legislature passed this gerrymander, and they wanted somebody to win, so they drew something all the way around an area that, to me, looks like smog for Lord of the Rings fans, but they call it a dragon. And if you have not seen it, you're interested, you're welcome to walk out when you're done. And a gentleman for the New York Times wrote the Kansas Tisdale, wrote an article and called that a gerrymander, and then in parlance it became a gerrymander. There are intellectuals today who still call it a gerrymander, but in normal parlance, that's a gerrymander, and we're going to talk about how it spread from there. It was not before, but where it is today.
Right, and
So what is a gerrymander, Maureen?
a gerrymander is taking your map, you look at the entire state, and you divide it up. Okay, that's not a gerrymander, that is a redistricting. You redistrict. But the question is, how do you redistrict? What are the factors that you think about when you redistrict? And there are some legitimate factors, and then there are some what we like to call evil or pretty illegitimate factors.
And under the federal constitution, 2010, 2020, 2020 is coming, are everything, because that's when the census occurs. When the census occurs by the federal constitution, the number of representatives allocated to each state occurs. Pennsylvania has 18 seats today. After the 2020 census, we will have 17 because the population dropped. California, I think, has 53. They'll probably end up with 56 because people just keep streaming in there. And so now the state, the legislature, and it doesn't have to be the legislature, it's to them and they can delegate it, and we'll get to that. But in 37 states, the legislature now has to say, who loses their job? We got 17 instead of 18 seats, we've got to redraw these districts. And as important, apropos of gerrymandering, if Democrats are in control, how many seats can we keep and how many do we have to give to the Republicans?
So I'm going to point you to the maps again, to the handout, and through the good work of one of the clerks, we have a pretty neat visual of the situation. We're not going to go into a lot of depth again because of time.
Turn to page 1.
Page
If others don't have it, we will try to talk you through it.
Yeah, we'll talk you through. So page 1's picture 1, it's the green and the orange.
So you have the Orange Party and the Green
Green
Party.
Party. The Orange Party has basically 60%, and the Green Party, you only have the one in the loud one. You don't. You just have the map. Go ahead.
That's the wrong
You
one.
have it right there in the front page. The first page.
We'll talk you through.
Yeah, we'll talk you through. So 60%, 40%. That's the way the population looks.
And that's also assume the way it voted. So
way
if
it
you
voted.
look again, and I'm just talking about Pennsylvania because it's all I know. It can be any state. We just held a race for representatives. We have 18 seats. We aggregate the whole vote, and we look and we see that the Orange Party got 60% of the vote statewide, and the Green Party got 40%. Okay?
But remember, we're looking at districts. So you look at the second visual there, and you see these vertical lines, but you see proportionality, that the vote looks pretty much proportional to, almost identical to, the way the vote's split. So, okay, you get that. That's the concept of proportionality.
And if you live in Italy, the Orange Party would get 60% of representation, and their Green Party would get 40% because of the percentage of voting. The problem is then there's the Communist Party and the Socialist Party, they all get 2 or 3%. So most of the time they're forming governments, having governments fall apart. We in the United States have a winner-take-all. It has the advantage of stability. It may have the disadvantage that you can be gerrymandered out of your rightful share.
Okay. Now you look at the next one. Next visual, which is number 3. And you will see that in this visual, the Orange Party takes it all. Gets it all. By the way each district is allocated. So, basically 60%, 40%, 60%, 40%, every single district. So one party gets it all.
And again, for those of you who do not have the handout, this assumes 100 representatives in the House. So the Orange Party has elected 60. They put all 60 in 6 districts. They give the Green Party, they put 6, I misspoke.
6, okay.
They put 6 of their 60 in each of the 10 districts. 6 times 10 equals 60. That leaves 4 Democrats in each of the 10 districts. If that Democratic candidate cannot overcome a 60-40 voter registration edge, they're going to lose. It's likely, given the loyalty of voters to their parties in America, perhaps not this audience, but nationally, that that the orange candidates are going to pick up 10 of the seats, notwithstanding that the Green Party won 40%. Everybody with me?
Yep.
Okay. That's a gerrymander. That's a extreme partisan gerrymander that a court should look very hard at.
Now that's what is called cracking, okay? Cracking the opposition. Then there's the packing, and that's this jigsaw a little bit later that you see, where the districts are reallocated so that certain focus, certain intense party is in one area, but then the Green Party has a lot more ability to win. And out of that, you will get 6 green and 4 orange, despite the fact that the vote would go the other way.
So now the House and the Senate in our mythical state, which is controlled, it has a orange party, it has a Green Party House, a Green Party Senate, and a Green Party governor. Even though the public voted for the National House of Representatives, 60% orange and 40% green. Green still controls the state, regardless of what. Green goes in, they roll up their hands in the state legislature, and with the governor who's going to sign the statute's acquiescence, and they draw these squiggly lines every which way, and they somehow manage to get 6 green districts through packing and cracking, and 4 orange districts. And orange goes crazy. We won 60% of the popular vote. How can we have 4 of the 10 districts? Gerrymandering.
So, now move to the next, after the Jerry cartoon, to the next picture. And this was Pennsylvania before a recent Supreme Court case on which my colleague sat. And you will see by the ink that it's a pretty crazy quilt, isn't it? You look at District 12 in the west, and look how it just like straddles a couple different counties so that it keeps what the drafters felt was a power place, and go over to the east, and you see District 7. You see the green little District 7? It's connected by one width of a highway, one motel called Creed's Motel.
And as we're going to try, and Creed's is actually 2 pictures down, so you can see.
Pictures down.
Creed's is a restaurant. If you sit on one side, I went and tried it, in a table, you're on one side of District 7, the other side of the restaurant, you're on the other side. And they argued with a straight, I want to mention something else. They argued with a straight face in our court, that's continuity, contiguity. And I thought I had it. I said, so let's assume we make a district. Pittsburgh, for those of you who know our geography, and Philadelphia. And it's contiguous because it's connected by the Pennsylvania Turnpike. And they said, Your Honor, that's fine. I said, good for you for sticking to your position. I want to say something in all seriousness. This is not a party issue. In Pennsylvania, in 2010, Republicans won the governorship. Tom Corbett, a fine man and a good friend. They won the House and the Senate. And again, fine people. And they gerrymandered to their benefit. I guarantee you that they had a Democratic governor, a Democratic House, and a Democratic Senate, they would have done the same thing. So this has nothing to do with party, this has to do with the principles of what we want in our society. Because right now, we're in a place in our society where both parties are going to try to achieve as much power as possible.
So I'll just end with this and then start with the factors that are legitimate factors. Go back a few pages to the redrawn map. Okay? And you see that the redrawn map, it would be page 8. The bottom,
And that is the map that the majority of my court, and I was not in the majority, and we can talk about that, the majority of my court actually drew, it's court-driven, prior to the May primary. The U.S. Supreme Court has twice refused to intervene, and I think they will probably refuse a third time.
now, in that map, These are some of the factors that are reflected by the arguments made in front of courts across the nation. That the districts somewhat reflect equal population, but not somewhat, do reflect equal population, that there is a continuity of the districts, but something that looks reasonable, not this connected by one width of the turnpike. Compactness, keeping it together, not stretching it out. That's what compactness is about. Community. Yeah, I thought it was the link. And then there's another concept called community of interest, keeping the districts together so that the common interest is what binds the people. For example, again in Pittsburgh, because that's where we're from, and I'm just making this up, but there is a whole area in Pittsburgh that was devoted to steel and to the manufacture of steel. It is no longer, but that might be what might be an example of a community of interest. Something may be economically driven or culturally driven, but that also is a factor that sometimes gets injected into redistricting.
Well, let me say a couple things. I think this is really important. If you think about these factors that Maureen has just gone over with you, they're neutral. They're universal. They can result in a map that looks like page 8, which is the new Pennsylvania map. And it can also, to some extent, result arguably in the map on page 4. Although the map on page 4 we found was an unconstitutional gerrymander, so perhaps that's not so. Because the map on page 4 is not contiguous, is not compact. It is equal. They complied with Baker versus Carr. There's 711,000 people in every district. I wanted to stop because I think community of interest is extraordinarily important. Everybody talks about we want competitive elections, but do you? Assume there's a small microcosm here in this area of New York, and Chautauqua is a community of interest. And let's just assume that the 100,000 people or the 6,000 people that are here today can vote. Are you sure you want us to divide you in thirds so that nobody speaks for Chautauqua, but you get competitive elections with areas around you so that we balance this 50% Democrat and 50% Republican? Same thing, assume you're in the middle of San Francisco and you're a gay and lesbian community. You're in the middle of Boston and you're a university community. Are you sure you really want us to divide you so that nobody speaks for you? For your gay and lesbian community, for your intellectual community? So, you're in a large Jewish community in New York. Are you sure you really don't want a representative that understands you and speaks for you? And that's what community of interest is, and I think it's underappreciated in the whole analysis.
So, where are we right now? We are...
Through the legitimate criteria.
Right. No, I mean, there are goals.
We're a little off script.
Right. So what we are talking about is now, what are the arguments in front of the court? We already mentioned political question, justiciability. What's the language being used, and what is the means of demonstrating an extreme gerrymandering?
So let's talk for a second then on, does this matter or not matter? Because it's not, I hear all the people saying, well, we're turning into Russia. Well, we're not Russia. The president is elected by popular vote, putting aside the electoral college. Every senator from every state, that was not a jibe. I'm not into politics, guys. Every senator is elected. The House of Representatives should be your representatives. Community of interest, compactness, contiguousness. So are you sure if your community of interest is 711,000, which is what comprises the district, that has of one mind and wants one thing, that in the name of the competitive election, it should be broken up? So that's the argument, one of the arguments that that extreme partisan gerrymandering is bad, but non-competitive general elections is not necessarily bad because you're being represented by somebody who knows you, will listen to you, will understand you, and will follow. Does it hurt democracy? You have to decide.
So, how do we demonstrate an extreme gerrymander? And that's what the court looks at, an extreme gerrymander. At least that's what the court is looking at this moment. We've gotten over justiciability. The recent case called Gill established standing for a certain claim, but then Justice Kagan interjects another cause of action, which I'm sure we're going to be seeing, which is First Amendment violation, freedom of speech, freedom of association, and she uses the term vote dilution. Not so much extreme gerrymandering as vote dilution. So I just put that out there. And then now we move into, because these are concepts we don't have answers to, and we don't know how the court is going to be resolving them.
No, I was just going to comment again. Maureen's trying to go fast, but some of this is worthwhile. There's something in the law, something involving courts, that says that a question before us is a political question.
There's a Supreme Court case.
Yeah, there's an old Supreme Court case. If we deem it a political question, we shouldn't hear it. We're not into politics. We're not into policy. We're into deciding whether something is lawful or not lawful. And we should not get into the politics. So the argument was very strongly made that the issue of the composure of House of Representatives, the balancing of these various factors, is a political question and not a legal question. And the court should not hear it. The United States Supreme Court agreed with that until a case out of Pennsylvania, Vice versus Jubileer. And what did they hold in Vice?
In Vice, they held that the question of an extreme gerrymandering was justiciable, but that there was no manageable way to demonstrate it. So at that point, they did not have a good test that the court felt it could issue or state regarding how to demonstrate it. Now that was back in the early 2000s that case came down. Since then, statisticians have put their great wisdom to bear on this issue and developed a different number of approaches, statistically modeling these ways that extreme gerrymanders occur and do not occur.
And what's worthwhile, I believe, very good explanation for you, is the vote was 5-4. The vote is always 5-4 on consequential cases in the U.S. Supreme Court. There are 4 alleged conservative justices, there are 4 alleged liberal justices, and then there is Anthony Kennedy. And Kennedy was the 5th vote to say, this is not a political question, it's justiciable. But give me a manageable standard, as Maureen just said, or I can't decide this. I can't engage in subjective analysis. I have to have something that I can apply case after case with uniformity. The reason that's important is that Justice Kennedy has just announced his retirement.
And he's been viewed as the swing vote on many critical questions that have addressed the court over the past number of years. The argument might be that Justice Roberts might step in to be that swing vote. Depends who the next person to fill the court.
I said, those of us who watch the court hope so. Or we're looking at 5-4, and you will know the result of the case before they argue it. And that would be too bad.
Well, in any event, so right now, what we're looking at with Roberts is his very careful guidance of the Supreme Court, keeping it out of the political realm, because he has also, in many a speech, said that one of the pillars of our society is a court that can be depended upon to be outside the political fray. And that's really what they mean by the political question, that we have to have a court that people can feel has the integrity to make good decisions on legal issues. So with that, why don't we start with efficiency gap?
Sure, we can do that. What I thought maybe we should do, again, we're rehearsing on stage, so you'll forgive us. And so Maureen, I'll start this and you take over for me, okay? I thought this is worthwhile. The manageable standard is efficiency gap, Markov chain, mean minimum, we'll get to that in 1 second, and how that came to be and what it means. Before that, I really think it's worthwhile that you understand specifically the line of attack by people that are trying to say this is an unconstitutional extreme gerrymander. And that's twofold. They argue under the 14th Amendment. And you all know the 14th Amendment. It's the most famous amendment in provision in the Constitution. Equal protection of the laws, right? And the argument made is that if you just take Democrats and Republicans, and one has complete control, and they diminish the voting impact of the other, that that's a discriminatory intent, discriminatory effect, and no justifiable reason. And the party that has their vote diminished is being discriminated against. Their right to vote, their right to exercise that freedom, their right to do things under the law is diminished with no rational basis. There's no reason for this except one party wants more power than the other. Ergo, if you can prove that it violates the Equal Protection Clause, it's an extreme partisan gerrymander, you win. The other is the First Amendment. Maureen, why don't you take that?
With the First Amendment, it's quite different. It's the freedom of speech and the freedom of association, and that's the dilution of vote concept. But the interesting thing is how to defend that. When it comes to the First Amendment, the standard becomes compelling state interest test, least restrictive means. So it's a much higher, difficult test for a state to meet in order to be found constitutional. But we don't really know how that's going to play out.
You legal junkies, that's because it's political speech. Advertisement is sort of speech. Profanity is not much speech. Political speech is the most protected of all speech.
That's right. And the freedom of association is where Justice Kagan went in on this recent case that just came down in June called Gill. And she basically said, hey, you guys out there, start using this. And again, we don't know where that's going to go. So, 14th Amendment, that's the typical one, and actually the only one that really gerrymandering is at the Supreme Court.
Although, the reason we talk about the First Amendment is Justice Elena Kagan, who is, I like. I think they were all brilliant. They're positively brilliant. I think she's the smartest of the smart, and she's also streetwise. And what she did in Gill versus Whitford, and we're going to have to talk about Gill a little more, is they lost that case, the petitioners. They lost it 9-0, and they lost it on standing. Again, we're into the weeds a little bit. They brought it under the 14th Amendment, and they attacked all of Wisconsin's districts. And what the court held 9-0, not 5-4, in fairness to the court, they held that you don't have a significant enough, if you live in Milwaukee, you do not have a significant enough interest in somebody from wherever else, Sheboygan. Is that Wisconsin? Sheboygan. Thank you. Oh, I see a Green Bay shirt. In Green Bay, you don't have a sufficient enough interest in a representative in Green Bay that you can sue involving that. So somebody who lives in Green Bay can bring an equal protection argument on behalf of their representatives, and somebody who lives in Milwaukee can, but you can't do the whole state. So they lacked standing, they sent it back down. You may even want to comment that it was 7-2 on sending it back down.
Yeah, it was 7-2 because, again, the way it all split on the different issues. But the reason we keep coming back to Justice Kagan is she got 4 votes for her concurrence. And, you know, that to me was pretty awesome. That, you know, she's kind of trying to bring the court to something that it will be comfortable with. And I think that's about all we can say about that. The interesting thing is some of the, in the state case, and I can talk about this, the case was managed in Pennsylvania so that there was representation from every district. And I think that the standing issue, therefore, was not a big issue.
But there's 18 districts in Pennsylvania. The plaintiffs were very smart. They got 18 plaintiffs, 1 from every district. The defendants couldn't yell no standing.
So, just so we get to the talking, the question time period. There are these 3 statistical ways of looking at extreme gerrymandering. You can just Google this stuff, it comes up, it's really interesting stuff. There are also lots of websites that have maps out there that depends on, it asks you what your real concern is, and you draw a map as a function of your concern. I'll leave you with this, and then maybe in the question and answer, if you're interested, we'll go into some of these others. But there is one from Carnegie Mellon University, and it was statistically demonstrated to be reliable. And go back to when you were a kid, and you got to cut the piece, the pie, okay? You got to cut the pie, but your brother or sister or friend got to get the first piece, okay? Remember that. That's the basis of this CMU, statistical approach to doing effective partisan redistricting. And basically what they do is say, I get to cut, you get to choose, you get to freeze. So I say my party gets to propose a map, you, the other party, gets to freeze one section. You then get to cut up the rest of the map, and then I get to freeze one that I want, going back and forth, and for us it would be 17 times, okay? And they demonstrated to a statistical reliability that this is not only fair, but it is a very valid way of doing it. And we were just fascinated here, right up in our community, to come out with something that kind of makes sense.
In one of the cases in the United States Supreme Court, Justice Gorsuch, who's the most recently appointed by President Trump, said to the advocate, why are we doing this at all? A little bit political question. Isn't this for the legislature? And the response was, you have to do it, Your Honor, because it benefits legislators, benefits even the minority to the extent they get to keep their seat, their incumbency. And so only the court can do it. It's for that reason that I think that this suggestion, which makes eminent sense, probably cannot happen. It is not for the courts to do that kind of thing, it's for the legislature to do that by statute. And I don't know that any of our state legislators are interested in such a fair process. Let me mention the 3 tests. So, again, I hope everybody's following. We're going fast and we're trying. Remember, Justice Kennedy wrote in Vice versus Jubileer, look, it's justiciable, but I need a manageable standard. Nobody's had a manageable standard. In 2010, there was a Republican wave in reaction to 2008 when they got swamped. The pendulum swings. But 2010 was a fortuitous year. Why? Redistricting and gerrymandering. And so all these states became Republican dominated. Now, not every state. One of the cases in the U.S. Supreme Court is out of Maryland. There was a Democratic gerrymander there. So I'm telling you, both parties will do this. Just in 2010, it happened to be the Republicans. In 2020, it may be the Democrats, and then all the litigation will be brought by Republicans. So they needed a manageable standard. They got snookered in the state houses. And in Pennsylvania, in 2012, 14, and 16, we have 18-6. We elected 12 Republicans and 6 Democrats, just as it was planned. 60-40 each, or 80-20, 60-40. And what I said, and I believe, is candidates were fungible. That you could have run any reasonable American in any of those seats. And if they were a Democrat in a Democratic district, they would prevail. And if they were a Republican district, they would prevail. Now remember, that's not necessarily bad. Community of interest, compactness, continuity. But that, nevertheless, was the gerrymandering. So the Democrats start looking for, because they want to attack this in the courts, they can't attack it at the ballot box. They look for manageable standards to meet Justice Kennedy's admonition. And they came up with 3. One, and I'm going to do this really quickly and then you can all Google it. The efficiency gap. Now what that does, it's a complicated mathematical test. And it takes a look at wasted votes. So if the race, the prevailing candidate gets 60,000 and the non-prevailing candidate gets 40,000. All 40,000 of the non-prevailing candidates wasted, and 10,000 or 9,999 of the winning candidates wasted. Why do they also care about the winning candidate? Because you have cracking and you have packing. And one of the techniques is you pack, let's just, again, and I don't want to pick on anybody, let's just say that you have Democrats who are living in the center city, which tends to be. And so Philadelphia is an 80-20 Democratic city. So you say, that's great. You give them 2 districts, they're both 80-20, and you got rid of all those Democrats. So all over the suburbs of Philadelphia, you can have Republicans win. That's packing, and that's what you do. And that's why in the efficiency gap, you measure both, okay? That'll tell you the efficiency gap should be 8% or less. In Pennsylvania, it was somewhere between 13 and 21%, I think. I think that's right. The second test is also from Carnegie Mellon. It's called Markov's Chain, and it's really for computer geeks. But what the computer scientist did is he had about 200, 250 maps drawn. And he moved lines the littlest bit in the Pennsylvania districts. They did this in Wisconsin too. And the little movement of a line caused a precipitous change in the percentage of voters from the opposite party. Therefore, he concluded that those lines were drawn purposely in order to exclude those voters when they were originally drawn. That's called a Markov chain. And then the last one, Maureen, is mean and median. Again, mathematic. The mean is the average. So you take all the votes cast throughout any state and district, and you do the average, and you see what the average vote was for one party or the other. Assume that it's the losing party and they got 42.5% of all the votes. So that's your average or your mean. Then you look at your median, which is a dead set number. And if that number is 50% or higher, that means that you should have gotten more votes statewide than you got. And that you've been cracked and you've been packed. So, and I want to give this back to Maureen, but those are the tests that the plaintiffs, in cases before us, in cases before the United States Supreme Court, say, hey, Justice Kennedy, we need your 5th vote now. Here's your management standards. To which the Chief Justice, and the Chief Justice is a wonderfully nice man, I've had the chance to meet him, and the Chief Justice just was private school, first in his class, Harvard undergraduate, and editor-in-chief of Harvard Law Review. I promise you, don't do that without being brilliant. And he looked down from the bench, he says, it seems to me, these standards, he said, perhaps it's my education, but respectfully, this seems to be like the utmost in gobbledygook. And so that was his reaction to the management standards. Now, the court didn't get to decide that case. Why? Because they threw it out on standing, right? Gill versus Whitford.
So I think we're at that point, we've probably long past that point, where we can take questions. So why don't, if anyone has a question, please come up and we'll entertain them.
While you do that, I want to make one last point. The case in front of my court was under the state constitution. The Pennsylvania Constitution has a clause guaranteeing free and fair elections. The federal Constitution does not have that clause. We use that clause to set aside the gerrymandering, and it doesn't necessarily follow that a federal court can do so.
That's right. Yes, sir. Sir.
2 issues that are kind of tied together here. According to the Constitution, some people claim that only the legislature can do the redistricting. So if you would address how you folks did it versus the legislature. And second, when the Democrats won a majority in the last election of the Supreme Court justices, were saying, okay, they're going to do something there that benefits the Democrats. So it does give at least the
Appearance of impropriety.
Right. So how do you all feel? Justice O'Connor has been complaining nationally and campaigning for appointment of judges instead of elections. So if you would tie those issues.
Maureen, let me answer the questions, and you can talk about appointment versus election, okay? Because are you in the Pennsylvania legislature? I got asked the same question in front of the Pennsylvania legislature. But it's a good question. The question is, how can the court draw that map if the federal Constitution, Maureen read to you, said that the legislature doesn't? The court has the obligation, and you know this if you think about it, to correct unconstitutional actions that the executive branch or the legislative branch do not correct. So the federal courts over the years have directed that that children be bused, that schools be built, that school districts be consolidated, that jails be built. Those are all legislative actions. The argument in Pennsylvania is that the majority of our court, and I was not in this majority, did not give the legislature enough time. And Maureen, can you recall how much time they gave? Was it 3 weeks?
It was very short.
3 or 4
weeks might have been generous, yeah, it was very short.
And so the legislative amendment in Pennsylvania is that was not enough time. And the court's response, the majority of the court was, it was lots of time, you should have gotten it done. And therefore, we, the court, had a right to correct the unconstitutional gerrymander when you, the legislature, declined to do so. Nothing wrong with it in process. It's a fair question, was that enough time or not? I was an advocate that we should give them a full year, because I think legislatures are not very efficient. And therefore, I thought I thought it was unconstitutional, I voted it was unconstitutional, I wrote it, but I thought we should give them to 2020 rather than 2018 for new districts. But the majority decision was completely well-reasoned and rational and appropriate. It's just a question of how much time they get. And the second question, is there an appearance of impropriety? You know, I think we live with that. My colleagues are very fine people, and they're very fine justices. This is one case among the couple hundred we decide every year. I learned a long time ago that every time I make a decision, the losing party will go to their grave believing I was wrong. And I live with that, and we all live with that. So you can argue that 3 Democrats won, the court did this, and that's an appearance of impropriety. I would say to you that with 7 fine justices, I know I am, and I voted it was unconstitutional.
And on your third question about whether judges should be appointed or elected, we have a total election process in Pennsylvania, as you know, from the district justice, magisterial district justice through the Supreme Court. I was one of the very few who was appointed and elected. I was appointed by the governor and then later elected. It's a political process no matter what you look at. It's just the way it is. It depends what factors go into the political process and how important and how in-depth the process is. But, you know, we have what we have and we deal with what we deal with. And after this I could get into more depth with that, but I will just say that no matter which way you go, there are pluses and there are minuses. I will add the plus to the election is that many people would not get on that court if they had to go through an appointment process.
There are many, we're going to take the next question, there are many studies out there, again, Google is the font of all knowledge, that show that elected judiciaries are more independent than appointed judiciaries. And you want your judges to be independent. You want them to decide by law and facts and make a decision and not care who they offend and who they anger.
I'm from Georgia, one of the more gerrymandered states in the Union, and we've been trying to deal with this gerrymander issue, and one of the things that we've struggled with is marketing to the electorate, because the Harris poll has shown that more than 90% of voters are opposed to elected officials in the state using their power to keep their jobs. And we use that Harris poll to empower primary challengers for Republicans to bring in new voices to try and decrease the extremism of the legislature. And I was just wondering, in Pennsylvania, how did you market this difficult and rather dry topic to the population to support a more reasonable approach to redistricting?
Well, this was just we just sidebarred up here. The court imposed it. The legislature did not do it. And now, one of the things that, again, under our Constitution, the every 10-year mark is for the feds, but the states may be able to do it more frequently. That allowed this to occur as a challenge by the League of Women Voters could bring it a number of years after the map had been put in place. So that was the number one. Number two, it wasn't a legislative action. It was a party who brought the case, and therefore it was the Supreme Court who changed it. Now, it has gotten a lot of press, and I'll tell you what, the people in Pennsylvania, you go to any gathering of people, and this subject comes up. So have we gotten the electorate activated? Oh, yes.
And I add two things that I don't know Georgia at all. I mean, I apologize, I don't know the mechanics of the state. There are states that allow propositions. That's ballot initiative by citizens. You're not one of them. Because in California, that's how they got their system. The legislature would not pass it. The other thing is you may be able to push on your legislature not to do this. They won't do it. but for a constitutional amendment to give it to a commission. And there are 4 states in the United States that are, actually there's 6, but there are 4 that it has passed legal challenges, and it looks like it's going to go on the ballot for a constitutional amendment to the state constitution to allow a commission to do it. You might get some headway with that.
That's what we're working on now.
Good luck.
Thank you very much.
Yes, thank you for this fabulous discussion. So I have a lot of concern, as many of us do, about the census and the citizenship question coming onto the census and what that will do as far as voter suppression. And I guess one of my questions is, if, let's say that question actually does end up on the census, is that an issue that the courts can take up, and how does that affect the whole question about gerrymandering and hacking and stacking and everything else?
You're talking about the question about your,
It's the citizenship question that talked about putting onto the census for 2020.
put it back on, yeah, it was taken off, it was on before, taken off, and then put back on.
So you're really asking, would that be a political question? And I think it's not a political question. Having said that, and we have not mentioned this, legislatures are entitled, rightfully, to a strong presumption in constitutionality. In order to find any statute unconstitutional, you have to find it clearly, palpably, manifestly violates. Could you bring a case in the federal court on that? I know little about it, so don't take this as advice. I think you can, could you win it? My guess would be no, but again, I'm not a federal judge, and I don't know much about that.
So it remains a question we don't have an answer to because it hasn't really been ever brought up.
And the voter suppression.
It costs you $150 to file a lawsuit, take a chance.
I think,
I couldn't hear what you said, so I was listening to her. But
I said it will cost you $150 to file a lawsuit, find yourself a good neighbor legal or ACLU lawyer, and take your shot.
Most good government people believe that Iowa, of the 50 states, has the best system. So why are we screwing on with all these crazy formulas? We've got one state that seems to work with an independent commission. Why don't we focus on basically adopting the one state that seems to have gotten this right?
and you know, that goes back to our Constitution, that each state legislature has the ability to manage this.
Yes, but we're not talking about the very simple solution that Iowa has come up with. We spend all these times confusing everybody in this room on all these crazy formulas when there is a simple solution.
Well, I'm going to answer that because there's actually an interesting answer to that. I agree with you. I like California's system. I like Iowa's system. Arizona has done a pretty good job. The reason we haven't gone into that, and the reason we've gotten into all these complicated tests, is that's just simply not our business. We're not policymakers, I've already said. That's the legislative business. And as the advocate said to Justice Gorsuch, they're not going to change the system that benefits them. So that's my response. But your argument is to, and I actually say this from the bench on occasions, when somebody's arguing policy to us. Take your argument to the legislature. The courts can't help it.
You know, Ohio basically passed it overwhelmingly, sponsored by both Democrats and Republicans. So there are solutions to these things. I'm not even in favor of the ACLU, did not support that. But you've come close, political, two parties getting together and also finding a solution.
It's all about leadership, isn't it?
And I don't want to fight. I agree with that. My response is argue it to the legislature.
Yes, sir.
Yes, my name is John Calloway, and I want to establish my bias up front. I was a former postdoctoral fellow in mathematics at Berkeley. My question is, should Supreme Court justices have a minimum mathematical competency test?
And Dawn, I will tell you, we could use it. I have a law clerk, and she is a math major from Yale. And when any of these things arise, including these tests, I sound so smart, she spoon-fed me for a week to understand them.
No, actually, that is not, I love the humor that you gave us, but it is something that has been discussed, that shouldn't there be a staff person at the Supreme Court that deals just with these kinds of high-end statistics?
Don, I make one last comment. We do have lots of continuing judicial education, and I'm serious. think it's worthwhile to talk about whether we should get people from Penn, from CMU, from Penn State, that are fine schools, and maybe design something to teach us basic mathematics. And I'm going to actually take that home, so thank you.
I'm from northern Warren County in Pennsylvania, and I know that the redistricting is...
Judge Maureen Lally-Green, fine job.
Yes. And I know that the redistricting is based on population and continuity and all that, but how much can I, from Sugar Grove, have in common with somebody from southern Cambria County, or somebody in Potter County have in common with somebody in southern Perry County? It's such a great distance away.
You know, we deal with population, and I think that is probably one of the largest factors in why you have such a huge district.
Yeah, the problem is under Baker versus Carr, and I trust you all know this now, you're all constitutional experts. Each district must be uniform, and that's been it. There's always a problem where you draw the line. That's all the law is. And so after Baker versus Carr, well, what's uniform? 3%, 4%, 2%. And it was decided uniform is uniform. So these districts are within 1 or 2 or 3 people of 711,000 and some people. And so if you don't have enough people in Warren County, and I know you don't, you're going to get grouped with a lot of people to get to 711,000. The only thing you can do, what we talked about at the very beginning, and you can do it, is argue that we increase the number of members of the House of Representatives so that your community of interest is better represented.
Thank you for that question. Yes, sir.
For 2 centuries, both parties have badly abused gerrymandering. It doesn't matter whose ox is being gored. The question is, who will rid us of this menace? Sadly, the Supreme Court declined and said that it is not our job to aggrieve partisan harm. I would feel more comfortable about that from the Supreme Court if it were not for the decision in Bush v. Gore. Sometimes there is restraint, sometimes there is none. So my question is this: who will rid us of this menace? And will the metric geometry gerrymandering group that has worked so hard on the statistics on this be of help? Because if the Supreme Court won't do it, some entity has to.
And let me respond quickly. In Pennsylvania, my court did it. It was an extreme gerrymander. And as I said, we did it under the state constitution. I think with the retirement of Justice Kennedy, and assuming that Brett Kavanaugh is appointed as the next Supreme Court Justice, I do not expect that you're going to get relief. The chances, Maureen very well explained, is that John Roberts would swing. But I wouldn't want to put a lot of money on that. So my response to you is, bring your challenges in state courts under your state constitution. And I hope your state courts, like our state court, is fair and willing to be unpopular. If that's what it takes, it'll make the decision for you.
I'd like to add one thing: the power of the people. And I'll give you an example of how it worked. In our Commonwealth, back 15 years ago, we had a situation where in the middle of the night, there was a pay raise given to all 3 branches of government. And it was wildly opposed by the citizens. So much so that there was a pink pig, huge inflatable pink pig, on the steps of the legislature, okay? And there for months. And the newspapers and the citizens came to the front line and argued against it. What happened? Most of the legislators decided, well, a number of legislators decided not to take the pay raise. The executive pulled back on the pay raise. It became a big judicial issue because of the constitutional provision. You couldn't really reduce our pay. And I was on the bench at this point, so I was kind of watching it from the sidelines. But what also happened was this: virtually everybody involved in the voting or the management of that pay raise got thrown out of office.
Interestingly, including Bob Jubileer, who's a good friend and a fine man, and Jubileer versus Lee, he lost his seat over the pay raise.
Over the pay raise. So when you ask that question, I say the people. The people will be the people who do this. And it means getting out and voting and becoming involved in the political discourse in a way that makes a difference.
But it's unlikely that the United States Supreme Court will take this up in a substantive
It is
way.
unlikely.
Thank you so much.
Thank you.
And I wanted to make one other mention. The gentleman said that this has been going on for 2 centuries. True. The first gerrymander was actually Patrick Henry to try to help James Madison. He cut his home out of his district. It was the Democrat-Republicans versus the Federalists. And it was a mean-spirited debate over the power of the federal government. However, what has changed is technology. Today, the parties, Democratic Party, Republican Party, perhaps other parties, can fine-tune these maps to know if one half of your street goes in, what the impact is. If a senior citizen home goes in, what the impact is. If a subsidized housing goes in, what the impact is. So remember Markov's chain, the smallest change now can change the voting percentage and the winner. And that's because of computers, software, advanced technology. And that's the change that's made this, in the last 20, 30 years, so consequential.
Good afternoon, Your Honor. My name is John Zimmer, and I'm from the Great Lakes State, the state of Michigan, where we tried a different approach and developed a petition that had an overwhelming number of signers, valid signatures, that said that we would portion based on an unbiased group picked in Michigan. Now it got to the Supreme Court and they threw it out in Michigan. And I'm not sure I can follow how the Supreme Court reasoned on that, but I'm wondering if you have any insights into how that turned out.
Well, I don't know anything about Michigan. There are absolutely criteria for every statute that has to be met. In Pennsylvania, it has to be on a single subject, has to be introduced for 3 different days so that it can't be passed in the stealth of night, and there are other criteria. And so, if the statute that I thought was wonderful public policy was unconstitutional under one of those criteria, I'm constrained to throw it out. I don't know if that's what happened in Michigan or not. I would hope and trust that your court made the proper decision. Free advice, do it again. And read the opinion and don't make the same mistake twice. And I hope, again, I know a lot of judges. I've been on the Pennsylvania Supreme Court for 15 years. Before that, I ran family court in Pittsburgh for 13 years. 28 years on the bench. My experience is that judges are fair, are impartial, and try hard. And remember, if you lost a case, you'll never think we were right.
I have a comment for Chautauquans. I'll let you know what we did in Georgia. Since we can't depend on the legislature, we can't depend on the Supreme Court, a group of us in Georgia did individual lobbying at the state, and we blocked a gerrymander bill that had gotten through the House before it went through the Senate. And that can be done. You can do that on your own. I have blocked bills personally myself. So my wife and I go down there. We got 200 people down there on a Friday morning at 8 in the morning, and the legislators freaked out. And they stopped it. They didn't put it through. You guys can do that. You can empower yourself to change state government.
And this is the power of the people.
Yes.
Truly. You know, it takes just a few of us to do a lot of good. Yes. That's really something. Yes.
I'm formerly from Erie County, a community of interest that has been reunited under the redistricting plan in Pennsylvania. My question is whether these redistricting plans assume or require a 2-party major system, given that the federal Constitution makes no mention of political parties.
You know, it is kind of the way we are, isn't it? You know, with the redistricting. I guess None of the cases I've read so far go beyond the two-party system. It's just the two-party system, and again, that deals, because it's the legislature, you know.
Well,
Maybe
it's more than that, it's just the United States. I mean, we've had third parties, remember Ross Perot, was that his name, Ross Perot? And in Pennsylvania, we had Ralph Nader, the presidential bid, and, remember that? And they just don't get traction. There's nothing in the law that prohibits them at all. We're just a country where people tend to identify with these and I's. And again, if you can get enough, and then maybe you can't. Maybe now there's going to be a fringe left Democrat, fringe right Republican, and a middle party. But so far, even though those factions are out there, they have not translated into separate parties.
Thank you. That's it.
Let me thank Chautauqua, and especially John, who's been awesome, and Ed. Ed, you still back there?
Yes, he's still back
Ed's asleep back there. And thank you for your hospitality. Thank you for everything.
I have that.
Chautauqua, it's been a pleasure.